Hi, everyone. Thanks for joining us. Before we begin, I want to allow folks a chance to connect to the right language channel. So today for our ADA webinar, we will be providing interpretation in 4 languages. We have Cantonese, Mandarin, Vietnamese, and Spanish. So to access the right language for you, please click on the small globe underneath on the right-hand corner and select the language that you would like to hear for the duration of the webinar. So I'll just give folks a chance to do that. Thank you again to everyone joining us for the ADA webinar today. Today, the Lawyers Committee for Civil Rights of the San Francisco Bay Area has partnered with the San Francisco Chinese Chamber of Commerce to bring you this ADA compliance webinar and to help small business owners understand ADA compliance under their commercial lease. And so we will also be providing context to the ADA lawsuit process, and we hope that this will be greatly beneficial for all of you. First, we'll have Calvin Yan, who is a legislative aide to Supervisor Aaron Peskin, and he will give us an overview of ADA cases in San Francisco and provide some of that context. Then we'll have Attorney Bilal Shatila and CASP Supervisor Ann Riggs present the ADA workshop. And finally, we'll have a couple of minutes at the end for questions. So please feel free to use the chat function to ask any of your questions. And once more, if you need any interpretation, please click the globe, the small globe, to change the language so that you can listen to that language for the duration of this webinar. All right, thank you, Calvin. You can take it away.
I'll try to be brief. I know that we don't have a lot of time. Hi, everyone. My name is Calvin. I am a legislative aide for Supervisor Aaron Peskin. Supervisor Peskin represents District 3, including neighborhoods like Chinatown, North Beach, Nob Hill, Polk area. And first thing I want to thank Lawyers Committee for Civil Rights and Chinese Chamber of Commerce for having this webinar. Some of the conversation that our office is having with the chamber and the Lawyers Committee for Civil Rights kind of started actually last year, over a year ago, when Chinatown merchants, small business owners, a lot of them were immigrant, monolingual, have received ADA complaints in the hundreds. There was a lot of complaints. And hearing from the community, we realized that Chinatown merchants have experienced a similar slew of complaints about 6 or 7 years ago. And I think the point of this webinar is really trying to get a lot of merchants to understand the process of what these ADA complaints are and what they need to do. I still have merchants who are reaching out to us right now who thought that they can just ignore it and pretend that it doesn't happen. But as we can hear later from our attorneys and CAS special inspections specialists, that these things are actually very important for business owners to be aware of and take a proactive approach to it. And I just want to say that the city has also in 2016 passed a legislation to encourage small business owners and landlords to actually take a proactive step in ensuring that their business is compliant to some of these ADA lawsuits and complaints. That program is run by Department of Building Inspection. It has been extended for another 2 years. The deadline was actually last year during the pandemic, but because of the pandemic, DBI has extended that to another 2 years, and really hope to encourage the community to actually participate. And I know we'll learn more about that later. On and on, just want to say, we have a lot of our small businesses have experienced these ADA lawsuits and complaints. Want to make sure that everyone is taking actually paying attention to it and work with the landlords to make improvement, because we've been hearing from a lot of our community folks that it is cyclical. Just because you have settled something this time, doesn't mean that you might not get it in the future, and we want to make sure that we can plan ahead. So thank you again for Bilal, who's going to speak a lot more about the process. Thank you for Chamber. I know that Chinese Chamber of Commerce have provided resources to help small businesses, and I know that the Lawyers Committee for Civil Rights will continue to do that. And we're happy. I'm here. I know that it's not just Supervisor Peskin, but we have partnership from District 5 office, Dean Preston, District 1 Supervisor Connie Chan have all been working together to get this webinar organized. And I know that this issue is going to affect a lot of small businesses in different neighborhoods, not just these three. So thank you again for everyone to be here, and I will stay here if there's further question afterwards.
Thank you, Calvin. It's the legislative component of businesses is extremely important. I was actually in Arizona last month, and they don't have any ADA complaints to deal with because legislatively they were able to come together and pass a statewide law that required notice. Now, this is the biggest sort of issue with the ADA, which is the Americans with Disabilities Act, in that, number one, it's the most expansive laws on the books. It's the most expansive act that protects the biggest class of people, which is people with disabilities. The issue with it, unlike many other laws, is due process, meaning I give you notice that, hey, you're in violation of something. And usually, constitutionally speaking, there should be a period where I, as the business owner, can rectify that violation prior to being sued. It's just a principle of fairness. However, the ADA does not have any such notice requirement, which means you, as a business owner, almost always have to be on notice and taking steps to ensure that you're not another defendant in one of these hundreds and hundreds and hundreds of cases. Now, if you look at the federal court docket, you'll notice that the plaintiff, the person suing you, the store owner, and the landlord, is only a handful of plaintiffs, maybe 5 or 6, but they file hundreds of these lawsuits, and they're able to do so because the ADA allows a plaintiff, a person with a disability, to sue even if they do not go into your store. They can literally drive by, and the ADA allows them to still bring suit because they were too embarrassed to go inside, or the barriers were too, there were too many barriers for them to even be able to go inside. I know it sounds unfair again. However, each time that they drive by, or they come into your store, or they attempt to come into your store, and they're not able to do so, statutorily speaking, meaning within the law, it's $4,000 per occurrence. So if they drove by 4 times, they could sue you for $16,000 in statutory damages alone. On top of that, they get attorney's fees and costs. Attorney's fees have been approved at $500 an hour routinely. Costs can include the cost of filing the lawsuit, and a big cost is the CASP inspection, which is about $2,500 to $3,000 if you allow the joint site inspection to occur. Now, from the period you are sued, you have 21 days to file an answer. And because we're in federal court, there's no $500 filing fee like there is in state court, which is good, but we're still in federal court. And things in federal court move much more efficiently and much quicker than in state court. Right now in California state courts, the dockets are backed up for years, 2023, 2024, but in federal court, they are always on it. So technically, if you get served with a complaint, 21 days goes by and you don't do anything about it, then they will be able to get a judgment against you, the store owner, and the landlord, because usually they sue them both in the same lawsuit. So let me go back a little. Compliance is everything. If you and Ann Riggs, the CASP inspector, will speak about it. I always tell my clients I am an Arabic speaking attorney, so a lot of my clients are Arabic speaking, and they have been the victims, the defendants of these lawsuits in the last couple of years that I have represented. And I hate representing them because last year or the year before, I told them, hey, make sure you get a CASP inspector to come in every year. Every year, you get a CASP inspector every year to come in and do her or his review and give you some sort of certification. This is the only thing that will help you, really, because even an attorney, they're a CASP inspector, CASP. Even an attorney, all I can do is file the response, go to the joint site inspection, which is us and the defendants and their CASP inspector, go to mediation, negotiate as best as I can, and then settle. The reason it makes my job so difficult is because there are no defenses to this. This is a very technical set of laws. So if you're off by 0.25 inches, doesn't matter. They can sue you. And I can't use that to, negotiate. A violation is a violation, even if it's one, and even if it's a 1/10 of an inch, it's still a violation. Now, as a tenant, which most of you are tenants, and there's the business owner, one thing to be very mindful of, and a lot of people get this confused, is in a standard California lease agreement, they always, since 2008, the landlord is not responsible. In most cases, the landlord is not responsible. Even if they get sued, you have to pay for their attorney and pay for their remediations. Now, the next thing I want to talk about is remediations. It's fixing. You have a period this is assuming after you've gotten sued. You have about a year period to fix these violations. And that's much cheaper than the average settlement of these cases, which is about $15,000 to $20,000 with costs. And a lot of times, I'm a small business owner. I represent small business owners. We do not, as small business owners, we don't have 20,000 sitting around, in most cases, to just throw and give to the plaintiff because of the statutory penalties. So what we would rather do is, like I said, bring in a CASP inspector and she will produce a report for you. In that report, especially someone as talented as Ann, every single violation that you have, and usually, there could be hundreds of them, but what we see typically is 5 to 10 types, whether it's the slope on your door, it has to be under a certain percentage, 6%, and we'll get into that. Whether it's the counter, how high it is, how wide it is, right? These are all things that are really easily fixable. And not fixing them and ignoring them, that's how these lawsuits occur. So I'm going to pass it on to Ann for a detailed presentation on the specific ADA requirements but essentially you don't want an attorney. You don't have to hire an attorney. You have to hire someone like Anne, because the attorney is going to charge you because we have to, unfortunately, and we can't do much besides negotiate, and it's only going to make a difference of about $5,000 to $10,000. So Anne is your person, and I'm going to pass it to her, and I'll stay around for questions at the end. Thank you.
Thank you so much, Bilal. It's really educational to hear your explanation of how these legal cases work and what all the challenges are facing business owners when they find themselves involved in a legal case. As Bilal mentioned, I'll share my screen. I'm going to be speaking more in detail about the access requirements for businesses. I'll be speaking about, what exactly is it that not only that these people are looking for who are unfortunately targeting small businesses for these lawsuits, but also, the ultimate goal is to provide access for people with disabilities. And we'd all like to see the world be more accessible for everyone. But, ideally, we'd like to see that happen without causing unfair harm to our small businesses. So as Bilal mentioned, I'm what's known as a CASP, which is short for Certified Access Specialist. I'm also a licensed architect. I've been practicing architecture for over 10 years, and I've been a CASP for about 5 years. As part of my work as a CASP, I do facility evaluations, as Bilal has mentioned, which is where I go to a facility and I check it for accessibility violations. I also do consulting plan review for the state of California, and I also do peer review for architects. So I have a broad expertise in accessibility. Just a little background on me. So to speak a little bit more about what is a CASP. The Certified Access Specialist Program is something that the state of California created. They did this for exactly the reasons Bilal was mentioning, because California is an especially difficult state to be a business owner in, because we don't have these laws that other states have that are more favorable to business owners, but instead California actually has laws that are more favorable to people looking to basically legally enforce access laws. And it comes from a good heart. It comes from wanting to make sure that the civil rights of people with disabilities are protected. But unfortunately, it's become quite a challenge to balance that out and make sure that it's actually fair for everyone. So these CASPs, like myself, are people who are certified by the state of California to have specialized knowledge of state and federal accessibility standards. So I'm someone with this specialized knowledge. And what is it that I have specialized knowledge of? An accessibility standard is a set of rules that tell you what a building has to do in order to be accessible for people with disabilities. So the main two examples of this that we run into are the big one that we're talking about, the ADA, the Americans with Disabilities Act. But it's important to know that the California Building Code is also an accessibility standard. So the California Building Code, you may be familiar with if you've been involved in construction projects. This is a state law in California that contains all the requirements for new buildings. It includes, among those requirements, it includes the accessibility regulations. So this means that when you go to get a building permit, when you go to do a construction project, some of that code that you have to meet will deal with accessibility issues, and that'll be enforced by the local building authority. And what's important to understand about a building code is a building code applies whenever you build something. So if I built something in 1988, I would have complied with the building code that was in effect in 1988, and I'm done. I'm good to go. If I build a building today, I have to comply with the building code that is current in 2019. And then I'll be good to go forever with that until I make another change to my building. And then I'll have to comply with whatever the building code is at that time. A few things that are important to know about building code are that it applies whenever you build something or make a change to your building. And that applies whether or not you obtain a building permit. So even if you make a change that you don't have a permit for, you were still required to comply with the building code. And that's why it's really important whenever you do construction work to make sure that you're working with a licensed architect or maybe a licensed contractor might have sufficient knowledge, depending on the scale of the project, to really help you make sure that what you're doing complies with the current code. And an interesting thing, if you are doing a project where you're submitting for permit, and I really do recommend that you submit for permit, whenever possible, because it just gives you an added layer of someone checking to make sure that what you're doing is compliant with all the applicable codes. Cities are now required to have a CASP on their staff. So at the city of San Francisco, especially, I believe, has several CASPs on staff at the Department of Building Inspection, and they're top of the line people who are very thorough in their reviews. And you can request to have those people review your plans. And they're not going to be able to guarantee that they'll catch everything, but those are just some layers of protection that you have if you're doing new work to make sure that the work that you're doing is going to be good to go and complying with applicable requirements. And the California Building Code is actually aligned to the ADA. They contain very similar or the same requirements. California has some requirements that are even stricter. So as long as you've complied with the California Building Code, you have also generally complied with the ADA. Now, the ADA is what everyone has been talking about. It's the term that we're all familiar with, which is the federal level. This applies everywhere in the entire country of the United States. The Americans with Disabilities Act is a civil rights law. It's not a building code. It's designed to protect the civil rights of people with disabilities. But what that essentially means is that the local government in California isn't reviewing to make sure that you've complied. That's why we have this issue where individuals are going around filing lawsuits as the only means of kind of letting you know that your business is out of compliance with the ADA. So another way that the ADA is different from building code is that it doesn't only apply when you build a new building. A common misconception about the ADA is that if you have an older building, you might be what we call grandfathered in, where you are already existing, so you don't have to change your building. But that is not true. If you have an existing building that's older than the ADA, you're actually still obligated to do whatever you can within your ability to make your facility more accessible to people with disabilities. And they call this obligation readily achievable barrier removal. And that's a really important term to remember when you're dealing with trying to address ADA compliance issues. So basically, any sort of new building or new work that you do, this has been true since 1991 to 1993, or when all these compliance dates kicked in. But basically anything that's been built after the early 90s or changed after the early 90s needs to comply in full with the Americans with Disabilities Act, because that's when the Americans with Disabilities Act started. But if you have a building that is older than that, if something that was built before the early 90s, then you're subject to what's called readily achievable barrier removal. And what that means is that you only have to change those elements that are readily achievable for you to fix. So the definition of readily achievable in the ADA is easily accomplishable and able to be carried out without much difficulty or expense. So basically, it's not too much money that you can't afford it, and it's not too difficult that it just takes a huge amount of effort or it is disruptive to your business. So you would need to look at several factors to figure out if something is readily achievable for you. Someone like me as a CASP, I can tell you that something is out of compliance with the ADA, but what I can't tell you is whether it's readily achievable for you to correct it. I could tell you that you need to install a 50-foot ramp, but only you know if you have enough money to build the 50-foot ramp, or if there's even a way for you to build a 50-foot ramp without completely blocking your loading zone so that you can no longer conduct your business. There are some other considerations. I've actually never, full disclosure, I've never seen these crop up in practice, but if there was a safety or security concern, or a serious operational disruption to your business, that might also affect whether something was readily achievable. However, there are, some basic items that are generally considered to be readily achievable. This is actually a list that is specifically written in the ADA. They give you a list of examples of items that would normally be considered readily achievable barrier removal. So I'm going to take you through that list so I can give you an overview of some of these highest priority items that are probably readily achievable, that you would want to make sure to address as soon as possible to avoid running into any issues. And so that people have more access to your facility, so that you can have more customers of more diverse backgrounds and abilities. So the first item on the list is adding ramps. They give an example of adding ramps either to your entrance door or perhaps a curb ramp to help people get onto a raised sidewalk. As Bilal mentioned, the city of San Francisco did start a program. I'm sorry, it was Calvin who mentioned it. The city of San Francisco has started a program where they're actually requiring businesses to fill out a form and have their entrances evaluated and to go ahead and do this correction. That's how important this is that the city of San Francisco has identified this as kind of the number one item that they want to try and have all businesses address. Another item that is pretty common, and fortunately one of the easiest things to fix, is making sure that any movable furniture or shelves, anything you have that's not really a permanent part of your building, that it's organized in such a way that there's a wide enough aisle for people to get through your facility. Also making sure that if you have any seating, like dining tables, if you're a restaurant, that you have the appropriate number of tables that are big enough and have knee and toe space for a wheelchair to pull under. It has to be 5% of your total seating. I typically recommend having at least one full accessible table for each wheelchair seat required, because it's not always easy to seat two wheelchairs at one table. Another really common item that also is sometimes furniture are your sales and service counters, like Bilal mentioned. The height of your checkout counter would be an example of something that might be furniture that you could easily fix. Doors are another big example. The list specifically mentions widening doors and replacing door hardware, which I agree with them on one of those. Replacing door hardware is a really great, readily achievable way to make your doors more accessible. You can replace those old-fashioned twisty knobs with a lever that's much easier to operate without tight grasping and pinching. They also list widening doors as an example, which I'm not sure, just as an architect, how readily achievable it usually is to widen doors. That's usually a pretty big construction project. Maybe they mean interior doors with conventional wood framing. But I do see, a lot of issues around doors. Usually there's the force to open the doors. You don't want your door to take too much pushing to open. You also don't want your closer to be adjusted so that the door slams back really fast on someone before they have time to get in the door. You need to have clear level landings on both sides of your door that have to be a certain size. And you also, if you have multiple entrances and not all of them are accessible, you're going to want to put a sign on your accessible door, like the one shown at the upper right, that identifies this entrance as the accessible entrance. And then at other doors, you want to have a directional sign that lets people know which way they have to go to get to the accessible entrance. And there are lots of other requirements for doors, which there's, no way to explain them all right now. Another example of readily achievable barrier removal that's given is parking. Again, this is a really common issue that comes up as well. Fortunately, oftentimes this can be achieved simply by restriping your parking lot. The most common problem that I see with accessible parking is either that it's simply not there, or maybe it was done a long time ago and the striping is starting to deteriorate. That's a really common issue that people have, where they just need to restripe their existing parking. There are also really specific requirements, as Bilal mentioned, down to the inch of how this parking needs to be laid out. So sometimes I'll see someone who really made an attempt to provide accessible parking, but they don't have quite the right sign. It doesn't have all of the exact correct language. In California, if you only have one accessible parking space, it needs to be van accessible, which is a special size. And you need to have a special sign that says this is van accessible parking. And in California, you also need a minimum fine $250 sign. So if you just go online and you look up ADA parking sign, you might find something for sale that unfortunately does not meet the California requirement. So you really have to have someone who's an expert at the California requirements who can help you make sure you have all the correct striping and the correct signs. Another sign that's often missing is another California requirement, which is an additional sign that says unauthorized vehicles will be towed, and you have to have a towing company where you list their name and phone number so that people know where they can go to get their vehicle if it's parked illegally in the accessible parking area. Another example that's given is a lot of items that occur in public restrooms. Public restrooms contain many different items, all of which have specific requirements. Everything that's in the bathroom, from the grab bars at the toilet to the toilet paper dispenser, the mirror, the soap dispenser, the sink faucet handle, insulating the pipes under the sink, which side of the toilet the flush lever is on. Those all have very, very specific requirements. And I've seen lots of bathrooms in existing buildings where the owner did their best to make their bathroom more compliant. They installed grab bars, but there were still, maybe because the size of the bathroom was not the right size that it needed to be, or they, weren't familiar with every single requirement, they still have received a complaint saying that their bathroom was not accessible. So again, it's really important to have someone with expertise help you identify, what in your bathroom can you change to make it more accessible, and what would you need to do to make it fully accessible. And some of that may be readily achievable, but some of it may not be. Most bathrooms that I survey are too small to be made fully accessible. So you need to determine if it's within your ability to enlarge your restroom. And unfortunately, if your restroom was built after 1991, you do need to correct it and enlarge it. Another item that's listed is flooring, which I would expand to include paving and other walking surfaces. This is often, a pretty easy one to do, just keeping all your pavement in good shape so there are no cracks, gaps, and making sure that any mats or, carpets or anything that you have on your floor is pretty firm and stable. You want to avoid any thick, shaggy carpets or any transitions or thresholds that are too big of a vertical change in elevation. So those are the examples of readily achievable barrier removal. There could be many others, but those are the ones that are specifically listed in the ADA, and they are the most frequent ones that I have seen. I'm just listing here. I've already talked about most of these, but these are the top 5 items that I personally have seen on complaints filed against businesses. As Bilal mentioned, it's super easy to see the parking. You can literally see it from space. You can see it on Google Earth or from Street View, and someone can easily target your business based on that. And then again, the main entrance is that's the most important thing that's going to allow someone to be able to enter your building and obtain access to your goods and services. So making sure that your entrance is accessible is a really high priority. Again, public restrooms. If you have a public restroom, it almost certainly has something that's not strictly to the letter. You know, I've surveyed 1 or 2 restrooms that were mostly compliant, and those were in newer buildings that had been built after the ADA that had obtained permits. But even in those bathrooms, they still have a few minor corrections that they could make. So it really, you need to go over your restrooms with a fine-tooth comb. And then sales and service counters, those are on most of the complaints I've seen. And then for restaurants, there's usually a mention of dining tables, or they're not, even if there is one accessible table, they'll mention, oh, that there weren't enough of them, or that the sticker that had the wheelchair symbol on it, which is called the international symbol of accessibility, that the sticker was missing. So how can a CASP help you? I think Bilal kind of mentioned it already. It's great when businesses are able to address these items before a lawsuit happens. So what a CASP can do is they'll come to your facility, they'll do an inspection, they'll make the report that Bilal mentioned, they'll recommend corrections. As I mentioned, the CASP cannot tell you what is readily achievable for you, but what we can do is we can help talk through it with you and figure out what you think is readily achievable, and we can help you put together a schedule of changes of when you think you'll be able to do things. And you could say, you know, I don't know when this is going to be readily achievable for me, or maybe it'll be readily achievable in a few years. Bilal will probably not like this idea, but this is the technical requirement for a CASP report. I'm sure Bilal will say to fix it as soon as possible. But once you have this report from a CASP, we'll give you a certificate, and it's a little blue paper, and it says that your facility has been inspected, and you can post that on your window. And that helps kind of hopefully let people know that your business isn't the best, you know, the best target if someone's looking to be predatory. And hopefully it also lets people know who are genuinely looking to access your facility that you've made an effort to improve your accessibility, and they may be able to come in and take advantage of your goods and services, which is really what we want at the end of the day. I think that's it for my slides. I have a convenient question and answer slide. But I'll just stop my share.
Thank you, Anne. I answered a couple of those questions in there, but.
Yes, thank you so much. Thank you so much, Anne and Bilal. I can help field those questions. I saw that there were some questions in the chat. So I can bring those up again. 1 second.
Counter.
Let's see. We have, well, one of the last questions was, how much does CASP cost? If folks weren't able to look at the chat, would y'all be able to answer that?
It ranges from about $1,500 to $2,500. And this is something that Ann and I were talking about last week, is that if more businesses actually utilize a CASP inspector, then a CASP inspector can theoretically maybe charge a little less. And like Calvin said, I think it was Ann that said it actually, there are CASP inspectors that are sometimes available with the city, but the city standard might be different than the ADA standard. So the city or the county might give you approval. They'll say, yep, it's accessible, but that's a different standard than the ADA,
Right.
which might get you in trouble.
Right. They do not review for ADA compliance. And there's no, you know, whether it's accessibility or fire safety or anything, the building department is never going to guarantee that they've, you know, checked your facility and that it complies with all requirements. Thanks, Bilal.
Yeah, and for the question, does a CASP report temporarily block a drive-by lawsuit? It doesn't block it, but it mitigates it. One thing I was able to do in a previous case, my client, he listened to me before he was ever sued, before this plaintiff ever came in. He got a CASP report and then he made the remediations. So once he was sued, he called me. I was able to file a motion to dismiss, $0 to the plaintiff or attorney's fees and costs.
We had a question earlier on. Apologies if you both have already answered this, but the question is, can you define public restroom? We are a private club and don't provide bathroom use to non-members. Would this also apply to us?
And I'll let you answer that.
Yeah, I can definitely take that. Well, first of all, I would say you definitely want to have your specific situation reviewed. And I think, I don't know if we've provided my email address, but I'm happy to, give advice without being hired. Feel free to reach out to me. I'm happy to answer, simple questions. Always happy to help. But typically a private club is not considered a public accommodation. So that would not be considered a public restroom, but it really depends on exactly how your facility is used. If you host an event where you invite the public to come in, if you sell tickets, then, and people are using those restrooms, now it is a public accommodation. And again, that's just a general answer. I would have to, review your specific case to give you a definitive answer.
Another question we have are historic buildings exempt?
There is a specific portion of the ADA that tells you exactly to what extent historic buildings need to comply. There are certain exceptions that a historic building can use. And the good thing is the ADA, you basically a historic building doesn't have to do anything that destroys the historic significance of the building. So that's why you'll see a lot of historic museums where maybe, no one can get into this building, but they have an audio tour or a video tour that they've put in an accessible location outside. But at the same time, the building does have to be a designated historic building.
Very few buildings.
Very few buildings. Yeah, just
Yeah.
being old doesn't count.
Right.
And then there are very specific exceptions. Your ramp can be a little bit steeper, but you still need to have a ramp. It's not just that you have a blanket excuse to not do anything. You can keep your doors narrower, but you still have to do what you can.
Thanks, Anne. We have a couple more questions coming in. Also feel free to check those out. So another question we have is, does a takeout only need a compliant ramp?
It would depend on where you are, where the people have to come to get the takeout. I think, and it also would depend on when the building was constructed and when any changes were made. If this is like an ancient Roman takeout window, then you could probably argue that you can just, call this number and I'll bring the takeout to you. But if it's a newer building, then no. If any member of the public can come inside, then every member of the public has to be able to come inside.
And that's the key, I think, and that to get to the heart of that question is, I've had clients completely close accessibility to the inside to everybody. They put a window and serve everyone from the sidewalk. If your store is small, 500, 1,500, 1,000 square feet, it's something to actually consider.
Yep, I've recommended that as well.
Yeah.
Sometimes it's just the easiest way is, do you really need to let people in here? But
Right.
then you have to explain to people that means nobody, really nobody.
Yep.
You can post a sign that says, no public access, etc., with instructions on how to access your services. And it should be equitable. Always bear that in mind. Is this equal? Is everyone equally served by my business?
Yeah, you definitely can't put a sign that says no disabled people allowed.
No, that's the wrong answer.
Another question we have added to the chat is there anyone on the state level, government level, working on legislation to address drive-by lawsuits in California? Do y'all have any answers to that?
I personally don't know any. I've emailed legislators and I've gotten a response from one that said that there isn't enough political support to introduce that type of legislation. So as business owners, and this goes generally to all of the laws that govern our businesses, I think it's so important to push for legislation in a way that all of the businesses are organized, because California, the problem that I see with California businesses, obviously there are so many, but other states, they have very strong chambers of commerce. And it's not just, you know, the Arab American Chamber of Commerce or the African American Chamber. These all exist, but the way that they come together and work together to pass legislation, it's not the same here in California, unfortunately, especially with small businesses. I would like to see that change, and I'm always here for that because that's ideal. And do you know of any legislative efforts or?
I don't. And, you know, my thought on it, as far as your comment about the political will, and you probably can speak to this even more than I can, but as a CASP, the businesses, I think Calvin also spoke to this. Unfortunately, the majority of businesses that I see that are being targeted by lawsuits are in less, sometimes they're in less affluent portions, less affluent business districts. They are the business owners that are have the least resources. So there's really, I think that maybe the case needs to be made to the legislators that we're making a trade-off here where the burden of one civil rights law is actually affecting another civil right, which is the ability of business owners to have a fair shot at you know, being successful in running their businesses. And I think that hearing from you know, communities, representatives in these communities like Calvin and like chambers of commerce may help to kind of show that, you know, maybe this does deserve some more political will. This isn't just, you know, wealthy. This isn't Starbucks that's suffering.
Yeah, Starbucks never gets sued.
Starbucks did get sued, but they won.
Oh yeah, well, they've got a legal team of 12 people and $1 million budget
Yeah.
to defend those.
Hi, Ann. I just want to add that, like, as far as this is a state and federal law, I do encourage everyone to contact your state and federal representative. You know, in San Francisco, I think we're trying our best to work around what's existing and what we have to work under. And certainly, I think various departments are aware of it because of continuous complaints and continuous concern from the community. And our office is always there to, you know, receive and trying to refer back to our state and federal representatives. So if anybody here in our district or another district, contact your local legislators in the district, and have them forward your concern directly to our Assembly people and also Senate, and ensure that they are aware of the situation. Yeah.
Thank you.
Thank you, Calvin. That's so important.
I see a few more technical questions in the chat. Would it be helpful if I answered some of these?
Sure, we have a couple of minutes left, and then we'll wrap up.
Okay, I see one that is sort of maybe applicable to a few situations. Someone is asking, what happens if entryway compliance is technically infeasible? So there's an interesting thing there, which is that there's no method under the ADA of documenting that something is technically infeasible. There is a method of documenting under California Building Code if something is technically infeasible. And a way that you can do that is to submit for a building permit and ask the city of San Francisco or whatever city you're in to determine that you have an issue of technical infeasibility. Same goes for if you have a historic building and you want to use a historic exemption. If you go through the building permit process, that's one of the only ways to really actually get documentation from anyone having authority that this is truly technically infeasible or truly a historically significant building. Again, that doesn't guarantee, that has nothing to do with the ADA, and maybe Bilal can speak to this, but I would hope that having that determination would be, you know, sort of some evidence that this would not be considered readily achievable under the ADA.
Definitely a nuanced response to that. It looks like there's one more. Maybe we could do the entry door.
Oh, yes. For the entry door, is it need to be auto setup or for some business request? Is this a question of, does it need to have an automatic power door opener?
Looks like that.
Yeah, so the only time that you need a power door operator, those actually are not required by accessibility standards, but when people often install those is if they have a door that's too hard to open and there's just no other way to make it easy enough to open. I actually have a little gauge, it's like a little spring that I take with me and I push it on the door and it tells me how many pounds of pressure I have to apply to open the door. And if it's more than 10 pounds, that's out of compliance with the ADA. And if it's more than 5 pounds, that's out of compliance with the California Building Code. So if it
And the
takes,
handle too, isn't it? The handle and the slope. So the door itself has several components that need to be in compliance.
yes,
And the
Yes.
door opener is a good way to sort of avoid a couple of them, but it doesn't
Right.
completely rectify the issue.
Yes, that's true. If you don't have a flat landing, sometimes that power door is a good way, especially in an existing building where you weren't required to have the landing originally. If you have the opener to open the door, then it's easier for someone to get in there in a wheelchair without needing to have a flat landing where they can maneuver. Counter heights are, if you do a new counter under California Building Code, need to be 34 inches high. Or you need if you have a longer counter that's higher, you can do just one portion of it that's lowered to 34 inches, but that needs to be 36 inches long.
Thank you. I think that is it for the Q&A portion. Thank you so much, Anne and Bilal, for presenting and for answering all of our participants' questions. Thank you both. And thank you, Calvin, as well, for providing that overview, as well as letting folks know that they can reach out to your office, to Supervisor Peskin's office. Thank you to the San Francisco Chinese Chamber of Commerce for co-sponsoring, and Cheyenne will also be sharing a couple of words. Cheyenne, 1 second. Let me just switch you for a sec. All right, now we can hear you.
Great. Thank you. Thank you, Nicole. And thank you, the team, for hosting and presenting the ADA workshop today. This is really important. This workshop is, contains a lot of very helpful information. In the last couple months, San Francisco Chinese Chamber have helped some small businesses conducted this test inspection report, many of the similar problems, and we have discovered it. And so, this workshop is really helpful, and I appreciate that, and looking forward to continue to collaborate and continue to host more informative workshop like this to continue to educate our small business owner on their rights and what they can do. I could be reached by my phone number, that which I think Nicole is going to share on the chat. Welcome to call us, and we're here to help. Again, thank you. I thank you for hosting, and San Francisco Chinese Chamber. It's also very honored to be part of this co-hosting.
Thank you, Cheyenne. I'd love to work with your organization as well, so I'll definitely be reaching out to you.
Yes, thank you. It's great to participate in this. Thank you for hosting.
Thank you.
Hope it was
And
helpful.
we will be following up with participants to share any resources that might be helpful. On March 8th, we will also have our next webinar on bankruptcy. And if you do need any further legal assistance, you can email us at lse@lccrsf.org. But again, we will be sending out that information to all of the participants.
Thank you. Thank you, Nicole.
All right. Thank you, everyone.
Thank you, Nicole. Thank you, everyone, again.
Thank you. Bye.